Video we'll be going over IRS Form 56, Notice Concerning Fiduciary Relationship. Taxpayers use this form to notify the IRS of either the creation or the termination of a fiduciary relationship under Internal Revenue Code Section 6903, and it's also used to provide the qualification for the relationship under IRS Internal Revenue Code Section 6036. You cannot use this form to update the last known address of the person, business, or entity on whose behalf you are acting. Instead, use either IRS Form 8822, Change of Address, or Form 8822B, Change of Address or Responsible Party for a Business, to update the last known address. Form 56 should be filed by the fiduciary to notify the IRS of the creation or termination of this relationship. If you're acting as a fiduciary on behalf of an individual, estate, or trust, you can use this. Receivers and assignees, for the benefit of creditors, would also file this to give notification of their qualification. However, bankruptcy trustees, debtors in possession, or other similar fiduciaries in a bankruptcy proceeding are not required to give this notice. Trustees in bankruptcy proceedings are subject to notice requirements under Title 11 of the U.S. Code, which governs bankruptcy rules. Also, do not use this form if you're notifying the IRS that you're the authorized representative of the taxpayer. You should instead use Form 2848, Power of Attorney and Declaration of Representative. So this begs the difference. What is the difference between a fiduciary and an authorized representative? The difference is how the IRS sees the representation. For a fiduciary, the IRS treats that person as if he or she is the actual taxpayer. And upon this appointment, the fiduciary automatically has the rights and responsibilities to undertake all actions required of the taxpayer. For example, filing and paying taxes on tax returns. On the other hand, an authorized representative is treated as an agent of the taxpayer. They can only perform duties and assignments as authorized by the taxpayer, as indicated on Form 2848. The authorized representative is not required or permitted to do anything other than what is specified in writing by the taxpayer. So the difference between a fiduciary and a representative boils down to what they are required to do absent instructions from the taxpayer. A fiduciary is required to act as if he or she is the taxpayer, whereas the representative is only allowed to do what the taxpayer has authorized them to do. So we'll briefly overview the form, and then we'll go step by step through the instructions. So this is a 2-page tax form. Part 1 constitutes the identification. Part 2 is a revocation or a termination of notice. Part 3 is court and administrative proceedings. Part 4 is the signature field. So in Part 1, you'll need to provide all information specifically required, and if there's more than one fiduciary, then each person must file a separate Form 56. You also need to file a separate Form 56 for each person that you represent in a fiduciary capacity. For example, if you're filing a decedent's final individual tax return on Form 1040 and you're also the executor of the decedent's estate, then you would need to file one Form 56 on behalf of the decedent, and then another Form 56 on behalf of the decedent's estate. So in each form, you'll enter the name of the person that you are acting on behalf of, their identifying number, This could be their social security number, it could be an EIN, an employer identification number, or it could be an individual taxpayer ID number. If you're acting on behalf of a decedent, then this identifying number goes here. This would only be used if you're acting on behalf of a decedent that's filing either filing a final estate tax return. Then you'll enter the address, so 1111, oops. Huh. The fiduciary's name, you can put a telephone here, optional, so you don't have to. And then in section A, you're going to complete the appropriate fields for your particular situation. You'll check 1A if you if the decedent left a will and you're the executor and you've been authorized by a court, you'll have to enter the decedent's date of death here in line 2A if that's the case. If there's no valid will that exists, but you were appointed as the executor of an intestate estate, then you would select 1B. And if you're appointed by a court as a guardian or conservator on behalf of another person still living, then you would select 1C. And then if there's a fiduciary responsibility for the estate itself, then you would select 1D. Only if there is no court-appointed administrator or representative and you're the only person charged with their property. So for 1A, B, or C, you'll enter the date of death. For E, F, these are either a valid trust or a bankruptcy assignment. And if either of those are the case, or if there's another proceeding, then you would enter a short description of however you were assigned. And then if one of those boxes are checked, then you would enter the date of appointment, the date that you took office, or the transfer of assets. In section B, you will check the appropriate boxes under 3 and 4 for the type of taxes and forms that you'll be filing. So for an individual, it might be an income and estate tax. It could be generation skipping transfer tax. You could be filing a gift tax return. For a business, it could be employment or excise taxes. So based on your particular situation, and again, 706 series for estate taxes, 709 for gift, quarterly and employer taxes, 1040 or 1040 SR on behalf of individuals, 1041s for estates and trusts, 1120s for S corporations. Or if there's another tax return that you don't see here, just you can list it. For 5, if your authority as a fiduciary does not cover all tax years or periods, then you check the box and you specifically list the years or the periods within your authority. In part 2, this would only be completed if there's a revocation or a terminating of a prior notice. Completing either section B or C does not relieve the new substitute fiduciary of the requirement to file their own Form 56. So if, for example, there's a court order that revokes your fiduciary authority, then the entry in 6A would simply be checking this box, providing a copy of the court order. But if there's a new substitute fiduciary assigned and you check box 8, the new substitute has to file their own Form 56. But you would also include their name. So John Doe, 1, 2, 3, for example. If there's a partial revocation, then you would check that box if you're revoking an earlier notice, and then you would grant, provide specifics on, who was provided the fiduciary relationship responsibility in there. If there's a certificate or a dissolution of a business entity, then you would select that. If there's some other reason why there is a total revocation or termination, then you would indicate why. So in part 3, we will go through, this is assignment based on court or administrative proceedings. You only need to complete this part if you've been appointed in a proceeding other than a bankruptcy. So if you were assigned for the benefit of creditors, then you must attach a brief description of the assets that were assigned to your purview, and then an explanation of the action to be taken. For example, you can have hearings or meetings of creditors, sales, things like that. So if you were otherwise charged to liquidate, the accounts of a business that filed for bankruptcy liquidation, you would enter that. You would enter the business assets that you've been charged with disposing of. And then in part 4, you're signing this form under penalty of perjury to declare that this document and any attachments are, to the best of your knowledge, true, correct, and complete. So you'll sign and then enter a title if you need to, followed by the date. That's all we have for this article. If you, for this video, if you have more questions or you want to go more step by step, we've written an in-depth article covering this topic. Simply go to our website, teachmepersonalfinance.com, type in IRS Form 56 in the search bar, and our article should appear. If you like our articles, please subscribe to our newsletter. If you like our YouTube videos, please subscribe to our YouTube channel. And as always, if you have any questions or comments or concerns, please post them in the comments section or send me an email. Thank you.